Welcome everyone to today's webinar, New York State Pay Transparency Laws, presented by Michael Sciatti with BARCLAY DAMON. Many thanks to our presenter, Michael, for being with us today, and to all the participants who have joined in, and to our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share with what we learn with the business community. All attendees will receive the link to the recording. Michael will share the presentation with you, then follow with time for questions and discussion. Please use the chat to submit any questions during the presentation. Just a reminder, when others are speaking, please keep your audio on mute to minimize background noise. With that said, I'll turn it over to Michael to start things off.
Great. Good morning, everyone. Thanks for having me. Welcome to today's webinar on the wage transparency laws, plural, and I'll explain what I mean by that in a second. I will preface this by saying I don't think compliance with these laws are going to be difficult. I think it's something you're going to have to plan a little bit. I think you're going to have to see what type of advertising that you do out there. I think, when we get to the state law, which is awaiting the governor's signature, you're going to see we have some lead-in time on that. That will give the Department of Labor some time to give us some regulations and or guidance. And we'll talk through some of the potential issues associated with the new law in that regard. So, the PowerPoint, I think, was just sent out to everyone, along with a series of appendices that I will explain what they are in a moment. So let's go through this. A few things. I've given you my contact information in here. I'm also on Twitter and LinkedIn. LinkedIn, I will let you into my network. Twitter, you can just follow. I constantly post things, not only that are labor and employment related, that are related to lots of different areas of the law. We also have a labor and employment podcast. It's a quick, simple way for you to stay up to date on the ever-changing alphabet soup of employment laws and how to subscribe there. And we also have a cyber podcast as well. Again, simple ways, just like this webinar, to stay up to date. Now, the main difference, a podcast is quick. This webinar is going to be much more in depth than something you'd get in a podcast. So what are we going to talk about this morning? First, I'll give you some general background on the pay transparency laws. It's part of, if you heard about pay equity laws that are out there, this is one of them. It's sort of going through the state and other states right now. We're going to talk a little bit given your location, and I've actually been talking about this statewide. The City of Ithaca ordinance has been in effect for a little while now. We're going to talk about what that ordinance says. New York State, if the governor signs the law, is going to require one more thing in the disclosure of job descriptions if they exist. So the law does not require that you prepare job descriptions. The law simply says if you have one, you're going to have to make it available to the individuals applying for the position. We'll talk a little bit about job descriptions in a few minutes. And then I've given you some supplemental materials, which I'll go through towards the end. They're more for guidance and the big picture, because we're very early on in these laws here in New York. The City of Ithaca really hasn't given us any practical guidance, like what's a job advertisement? I don't know. I mean, I'll take some educated guesses. But then New York City has given us some detailed guidance under their law, what they think a job advertisement is. So, we'll have to sort of figure this out as we're going along. I suspect the Department of Labor, once we get a state law in place, will be giving us guidance that we will find helpful in the big picture. And that's assuming the governor signs the law, which I think she's gonna. I think it's a post-election day signing. I don't think it's going to be signed before election day, potentially for political reasons. And that's just my humble opinion, nothing more. So let's start with background. And you know, if you do have a question, feel free to put it at the end in that regard. Wage transparency equals wage disclosure. The intent of this law is very simple. Tell the applicant what the potential pay range is. Now, circumstances change and everyone's worried about it. The law requires that you tell them what the potential pay range is at the time you post it. You got, and that's your good faith estimate. Well, Mike, what happens if the following occurs? I get the resumes and I get 4 all-stars that I never thought I would see a resume from, all of which are demanding double the high end of the law. Do I need to repost? Absolutely not. As long as you can tell me with a straight face, our good faith belief at the time we posted it was this was the salary range. We get these great all-stars. We're going to have to double the high end, and that's why we did it. Okay, I'm okay in that regard. The converse is also going to be true. We got no resumes, Mike, of anyone remotely qualified for this. However, there was one person that had a glimmer of hope, and I want to offer her this other position at this other salary range. Is that okay? I think it is in that regard. You don't have to constantly repost under these laws, and you're going to see in a minute what I mean by that. The impact is you have to plan. What is that salary range? What is that hourly rate range? What if they're paid on a commission basis in whole or in part? We got to remember the commission sales agreement that we have to have in place with any one of our employees who are earning commissions. What if they're paid on a piece rate basis? You just have to describe it properly under the law. So commission. This position in whole or in part will be paid on a commission basis. You will enter into a commission sales agreement once you've been hired. Okay, you can put more information in there. I think that type of disclosure is what the state is going to be looking for. Mike, I own a Dunkin' Donuts. I'm paying $18 an hour. That's it. I can't pay any less just because I can't attract talent, but I also can't pay more because I got to sell a lot of donuts at $18 an hour. So I just want to say $18 an hour is what I'm paying. Again, I'm fine with that. And the laws are going to be fine with that as well. Again, relax. I don't think this is a big deal. I think it requires some planning on your part. Job descriptions, I've already mentioned. Under the Ithaca law, there's no requirement that you modify job descriptions or disclose job descriptions. If the version of the pay transparency law that has passed the Senate and Assembly is signed into law by the governor, you will have to disclose job descriptions for the positions if they exist. So a couple things to think about. One, is your job description accurate? Not just the pay range. Is it accurate? Meaning, do you list the essential functions of the job? Is the classification exempt or non-exempt appropriate? Do you have employees sign off on job description? And make sure everything in there is everything you need to be in there. So we got some time, as you'll see, under the New York version of this to get your ducks in a row. I'll get to that in a few minutes. You're going to have to do supervisor training. The law doesn't require it, but if you don't, you're doing yourself a grave disservice. I think maybe 4 or 5 years ago, when we started doing these webinars for the chamber, I did a webinar on salary history discrimination. You can't ask applicants about their salary history directly or indirectly. I encouraged supervisor training then, and I'm encouraging it now. Your supervisors might be asked by an applicant, hey, what's the pay range? Do you want them to respond? Number one. And then two, they need to know how to respond if you do want them to respond, or maybe you say you have to go talk to HR. I'm okay with any of those approaches, but they need a refresher on salary history discrimination, and they're going to need some training on what they can and cannot say in this regard, and that's going to involve some planning on your part. Again, the training is on this law. We're going to be done in 40 minutes. The supervisor training on salary history and pay transparency, it's going to take 40 minutes, 30 minutes, and not a big deal. The good faith affirmative defense. Now, remember I said when you initially posted, you had a good faith belief that the range would be between $50,000 and $75,000. That was your good faith belief, all right? That is your burden to prove in that regard. So when there is a affirmative defense, remember, it is the employer's burden to prove it. And I'm going to explain in a second how this law is going to come up in litigation. So just bear with me. But if you get into a situation where there is a claim filed against you under this law, you need to be able to explain yourself. That is the affirmative defense. There's a document preservation requirement under the law. Those of you that have heard me speak before, many of you have asked me for my document retention handout. Feel free to email it to me. It's about 50, 60 pages long. It covers all the employment laws and what the current document requirements are in that regard. But you will have to preserve documents under the New York State law. Plan some more. Some of you have assets in the city of Ithaca, but you also have assets maybe down in Elmira where this law is not in effect yet. Are you going to treat your advertisements in the city of Ithaca one way, or are we going to treat them the same in other parts of the state as well? I'd recommend to you that you treat them the same, because you got to get ready, because I think the state law is coming in that regard. And if it's not here this year, I think it's next year, but I do think the governor is going to sign it. I've heard two things coming out of the Business Council. Yes, she's signing. No, she's not. So we'll have to wait and see in that one. But I want you to plan. Planning is critical on this law. Okay, so how is this going to rear its head? Well, the alphabet soup of employment claims. Title VII of the Civil Rights Act, the sex or race claim. New York State and the feds both have equal pay acts. New York State has the human rights law. You could have a sex discrimination come up there in that regard. So you under Title VII of the Civil Rights Act, a plaintiff is 300 days to file a claim with the feds. Under the Federal Equal Pay Act, it's 2 or 3 years. 2 for non-willful, 3 for willful. Under the human rights law, it's a solid 3 years now, both with the division and straight out in state court. And depending on the labor law provision, it's anywhere, wage claims are anywhere from 2 to 6 years that you have to file in that regard. It just depends on the specific statute. So in a sex discrimination claim, let's stay with that. You hired a male. You hired the male at $20,000 over the high end of the salary that you advertised. The good faith affirmative defense comes into play, and you have to prove it. But you're also sued under the pay transparency law, and you're sued under the human rights law, and you're sued under Title VII of the Civil Rights Act. Wow. Yeah, it's all the same defense, though, isn't it? We didn't hire Johnny because he was a male. We hired Johnny because he was the most qualified candidate. Here's why. We offered him more than the high end of the salary. Here's why. I'd warn you on this. New York State Equal Pay Act claim are not quite that simple. There's burdens of proof, what you have to prove, how you can show it, etc. We will walk you through that in the event you have the displeasure of having a claim, but these are all going to be tied together. So that's how the pay transparency law can be violated individually or in conjunction with these other laws. Other states have these laws, not surprising. California and New York typically lead the way, along with New Jersey, Pennsylvania, Colorado. So some states that currently have these laws: California, Colorado, Connecticut, Maryland, Nevada, Rhode Island, in the state of Washington. The state of Washington will take effect in January of 2023. There are other cities out there. They're called local laws. That's what the City of Ithaca law is. It's a local law. So we got Cincinnati and Toledo, Ohio, Jersey City, New Jersey already have these laws. The City of Ithaca is currently in effect. New York City is now in effect. It went into effect Tuesday. So that went into effect on November 1. And Westchester County is about to go into effect on November 6th of this year. Albany County is also debating this law. I looked this morning. It has not passed yet in that regard, but I think that's another one. If you have assets in Albany County, you're going to have to be on the lookout for that local law. They're all a little different. But you have to comply with them if you have assets like in the City of Ithaca, in New York City, or in Westchester County, in that regard. The New York State law, I looked as of this morning. It is passed the State Assembly and Senate. It did so this summer. It is not yet delivered to the governor as of this morning. I don't know what the holdup is. Again, I think it's politics. In that regard, might be wrong, but it is an election cycle. So I think it's going to be signed, and I think it's going to be signed after election day. Just Mike's opinion, nothing else. Once the governor signs it, it will go into effect 270 days later. So let's say it is signed the day after election day. 270 days after that, the state law goes into effect. So unless you're in, Ithaca, New York City, or Westchester County, you're going to have 270 days from the date the governor executes the law and says, yeah, okay, we're in effect. So you'll have some lead-in time. However, if you're in any of those other jurisdictions, your time is up. We need to get you into compliance now. Before we talk specifics of the City of Ithaca, there's two types of these laws out there. One provides wage ranges to job applicants, sometimes only after the initial interview or upon request. Some require benefit disclosure. The first category is not us. We're in the second category. It basically you got to provide wage ranges and job advertisements. Well, that's going to beg the question, what is a job advertisement? I think posting on your internet or intranet is going to count. I think posting on social media by the company will count. Posting in a newspaper will count, online or print or both. But there will be some gray areas. And like, how can there be a gray area? Well, I had a very good question when I did this presentation down in the City of Ithaca. The question posed is, sometimes my employees or supervisors, through no encouragement by me, put on their private Facebook page, hey, we're hiring for so-and-so. Is that a job advertisement? If it's without the consent or knowledge of the company, I think the answer is no. If it is with the consent of the company or directed by the company, I think the answer is yes. So be careful. And the other thing, when I say plan, Do you want your supervisors and employees doing such things on their social media pages? Maybe you do, maybe you don't. That's up to you. That is a business decision. All the laws that are in effect and the New York state law, they all will apply to new hires, promotion. So it's going to apply internally as well. Mike, will it apply in this situation? I'm going to promote Tina. Tina is my choice for this position. We're not opening it up for any job advertisements internally or externally. I'm giving it to her. Is that okay? Yeah, I think it is. I don't have a problem with it. The law does not say it is illegal. There's nothing that says you have to post a position. We can argue whether it's a best practice or not, but that's another story for another day. You have to give this good faith, if you have to post, good faith minimum and maximum, hourly, salary. If it's commission, you're going to have to disclose the commission. And let me just read you what the state law says about commission in that regard. You must disclose in writing in a general statement that the compensation will be paid on a commission basis. So I think very broad language the legislation allows, but that's what they're contemplating. And remember, the Department of Labor years and years and years ago, there's a law in the books for commission sales agreements. You must have a writing signed by the employer, signed by the employee, that indicates how they're paid, when a commission is earned, how it's paid, etc. The statute runs through a whole bunch of factors. That's been around for years. It's commission in whole or in part. And if you don't have it, you're out of compliance in that regard. And it is a very big deal. Remember your Wage Theft Prevention Act forms. That form has gone nowhere. You have to do it at the time of hire unless you're in the hospitality industry. And I think then you still got to do it every time there's a change in pay. You must, if there's a commission sales agreement, if there's an employment agreement, I want the signed copy attached to the wage theft form. So it's clear, here's an employment contract, sets forth the compensation in that regard. And I already mentioned some of these other states and locales require benefit disclosure. New York is not going to be one of them. Neither is Ithaca, neither is Westchester, and neither is New York City. We don't have to worry about that. And it's the range at the time of hire. We all know that an employee can make more money the longer he's with you in that regard. And so it's at the time of hire, not 10 years or 15 years down the pike. What if I have a union? I don't need to comply with this law. The collective bargaining agreement says everything. That is incorrect. You do have to comply. So you're going to have to look at the CBA, see what the pay range is for starting, and that's what you're going to have to put in the statement itself. Again, wage disclosure, wage transparency, that's what this is all about. You got to think it through. What do you want to hire someone at for this? Please remember salary history discrimination. Train your supervisors on both pay transparency and salary history discrimination, what you can and cannot ask, and when is the more thing you can and cannot ask in that regard. So make sure the supervisors know that, hey, you can't ask an applicant how much you're currently making at your job. Can't do that here in New York. Okay, let's talk briefly about the City of Ithaca ordinance. Really simple in that regard. The City of Ithaca, like Tompkins counties and other localities across the state, have local laws that protect against discrimination. This is one of them that they have done. This law went into effect on September 1 of this year, so we're about 2 months into it now. What was the city's rationale? They wanted to protect their residents from discrimination in the area of employment. They believe that the United States has a well-documented pay gap and based on race and gender, and I think that data is accurate in that regard. Research finds that if you do this, it will improve pay equity and improve employee retentions for employers. I think that is the case. The one thing I want you to be careful about, some of you have long-standing employees who have been with you for a very long time. As you bump up the lower rates, are you bumping them up as well correspondingly? Because they get grumpy if you don't, and you may have a retention issue, not at the low end, but the high end, if you're not doing that. And again, whether you want to or not is up to you. That's a business decision in that regard. Equitable employer relations are a matter of public welfare. Wage transparency empowers employees to make informed decisions in that regard. I also want to warn, given this one, don't go crazy with the range. Make sure the range is accurate. Well, we might go $50,000 to $210,000. Yeah, what are the likelihood of that? Not great. So if you're advertising that range, you're going to have a bunch of irritated applicants if they're only offered $60,000 in that regard. So use common sense and think it through. The intent is just to foster employee-employer relationships in the city of Ithaca. The City of Ithaca law, like all employment laws, defines what an employee is and is not in that regard. Very broad definition, an individual under your control and direction for that you're paying wages or other remuneration in that regard. An employee does not include someone employed by their parent, spouse, or child, that someone in the domestic service of any person, like a home health aide that you hire off the street as opposed to the agency. Any person who qualifies as an independent contractor. Look, I don't think the state of New York believes in the concept of the independent contractor. The law is on the government's side as to who qualifies and who does not qualify as an independent contractor. In that regard, the independent contractor can challenge their status, and the government can challenge the status of an independent contractor. Just remember that. Who is an employer? Doesn't matter what type of entity you are. It could be an LLC, a corporation, or partnership, a sole proprietorship that employs one or more employees. However, the term employer, as defined within the City of Ithaca Ordinance, does not include any entity with fewer than 4 employees in its employ whose standard work locations are in the city of Ithaca. So that's really what we're looking for. 4 or more employees working in the city of Ithaca. Doesn't have to be all the time. It's just that will be their standard work location. And if you have a job description, sometimes the job descriptions say a home office or what's something along those lines. Make sure those are accurate, because if you put City of Ithaca, you're going to have to comply with this law. The law also applies to employment agencies. The requirement of the law is really simple. It requires an employer, employment agency, employee, or agent thereof. Now, what do we mean by the term employee? That's your supervisor. If your supervisor is being asked what the job description is, they got to speak truthfully. So I think there's individual liability under this particular law. It applies to new hires, promotions, and transfers. You must state the minimum and maximum hourly or salary compensation for such position in a job advertisement in that regard. I've already mentioned this. It's the high and the low in that regard. And if you don't know if it's just the set amount, just list the set amount. The City of Ithaca has posted a few FAQs. I didn't check this morning to see if they've updated this in any way. FAQs I put up here, not very helpful. Let me just be frank. When did it pass? Who does it apply to in that regard? What employers are covered by the law? The only thing is this interesting thing here. It doesn't apply to temporary employment or temporary help terms, as that is defined in a very specific provision of the labor law. I had to go look what it was. I didn't know, but basically a temporary help firm means a business that recruits and hires its own employees to work for other organizations in that regard. Exception that comes out of the FAQs. Must you give the upper and lower? I've already answered that. If you're paying 50,000 and that's it, not a penny more, and that's what you want to say, and that's your good faith basis, put it. If you're paying 18 bucks an hour and not a penny more, not a penny less, do it. And don't go crazy if you do list the range, because that could come back to haunt you. Some supplemental materials that I've given you. Take a look at this one. Appendix 1 is the New York City Commission's guidance on job advertisements under their law. And I think it gives you some help in identifying what a job advertisement is and is not. Now, is that the same that the City of Ithaca will follow? Is that the same that Westchester County will follow? I can't answer that. I don't know the answer. But it is at least something for you to point to in that regard. I've given you the complete text in Appendix 2 of the New York City law. Appendix 3 is the text of the New York State law. Now, the New York State law does have some other things in it. I always joke, what would be a labor law provision without the ability of an employer applicant to come after you? There are civil penalty provisions that apply. They have pretty much the same definition of employer in that regard. There's a record retention requirement. It basically says the Commissioner of Labor shall promulgate rules and regulations to flush out the details of the statute. So very similar in that regard. I've given you as Appendix 4 the Westchester County law, very similar to the Ithaca law. And lastly, I've given you as Appendix 5 the sponsor memo to the New York State legislation that has passed the Senate and the Assembly, just so you can sort of see what their intent was, but very similar to the City of Ithaca's. In sum, I don't think this is a big deal. I know New York likes to pile on. I've always complained about that. You all have complained about that. But this is one of the easier ones to comply with. Again, once you know where your assets are, we plan, we do some supervisor training. Once we get some guidance, what is a job advertisement, we can sort of figure that out. In the absence of guidance from the Department of Labor, because the law hasn't passed yet, maybe rely on the New York City guidance, but it's not a get out of jail card free. The City of Ithaca could take a totally different view of what a job advertisement is compared to the city law. But at least it's something to hang your hat on in that regard. So again, very small part of the puzzle here in the employment world, but very important nonetheless for you to get in front of in that regard. So let me pause. Let me see if there are any questions that anyone has. And if you think of a question later on and you want to shoot me an email, yeah, go ahead in that regard. And as of right now, I'm seeing no questions. So I'll hang for another second. Okay, so seeing none, I will tell you our next webinar will be on the New York State whistleblower law. There was recently some amendments to that. Actually went into effect earlier in the year in January, but we'll we'll give you a PowerPoint on that coming up. Just another law, and I suspect there will be some other ones that the governor will be signing that will come out. So with that, let me turn it back to the chamber.
All right, thank you, everyone, and thank you, Michael.
You're
We'll
welcome.
share the link to the recording with you later on, and you can visit chemungchamber.org to register for upcoming webinars or find recordings of previous webinars. For anyone interested in chamber membership, please contact the chamber at info@chemungchamber.org or call 607-734-5137. Many thanks to Michael Sciatti and BARCLAY Damon, and to everyone for joining us today. Have a great day, everyone.
Take care, everyone. Bye-bye.